Good morning or good afternoon all. This hearing is in the matter of CFI 041-2024 and is being held by way of video conferencing before Her Excellency Justice Sapna Jhangiani, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Monarch Solicitors. Lead counsel is Ms. Serena Amani. The defendants are litigants in persons, represented by Mr. Aleksei Galtcev. Thank you, Your Honour.
Thank you. Okay, Ms. Amani, we haven't issued an order following yesterday's hearing, but I presume your client has updated you and has updated you on the purpose of today's hearing to address all these issues relating to the trial bundle.
Yes, Your Honour.
Okay, so I thought it might be helpful. I have seen the defendant submissions. I've seen what the claimant has said in the reply skeleton, which hasn't been admitted, but is extremely helpful for the purposes of today, insofar as certain paragraphs address the objections that have been made by the defendant. And there was something further filed this morning by the defendants. And I'm not sure if you've had a chance to see that, Ms. Amani, because I understand you may be joining us from the UK and it's very early in the morning there.
Yes, Your Honour. I've not seen any filings this morning. I'm actually still in the UAE, and my assistant solicitor, Alice, who was involved in preparing the bundles and filing, is online as well, because I thought if there's any questions that I can't answer, then my assistant solicitor is there in the UK to be able to answer those. But I think I should be able to manage to answer all the questions.
Thank you. Have you seen the defendant's short submission of this morning?
No, Your Honour, I've not seen that, no.
Okay, all right. So I'm going to start and just to make sure that we're all on the same page, just address what I would expect to see in the trial bundle, just so that can be our guiding principles, and then we can discuss whether the defendant's objections are made out and what should or should not be in this trial bundle. Yes, Mr. Galtcev. Good morning,
Your Honour. 15 minutes ago, I received a new bundle. So submitted by by the claimant. So it's a new version. And I just tried to understand what kind of version I need to have a look. So previous version or today's version?
Right. I haven't seen any new version. We're actually, now that I've thought about this and I've looked at the trial bundle and understood what the issues are, I think we're going to have to start fresh. So let me talk through what I think the guiding principles must be, okay? And I did actually issue some directions towards the end of last week, because I think some of these trial bundle issues arose last week, and I wanted to make sure there wasn't any confusion about what should or should not be in the trial bundle. But let me just restate them because I think it's important. Now, firstly, there shouldn't be duplicates in the trial bundle, but if they're there and they're unavoidable, we can live with them, okay? But given that I think we're going to probably have to have a fresh trial bundle prepared, it would be good if we can try and remove the duplicates to the extent possible, okay? But that's really a minor issue. The key issue is that what's supposed to be in the trial bundle is documents that are on the case record. Now, what do I mean by documents on the case record? So, for example, Mr. Galtcev, the defendants recently sought to adduce a witness statement from Ms. Lauren Lapointe, the CEO of Stallion Gate. That's not been admitted to the active case record. But if we look at the portal for this matter that we all have access to, I could find that statement. It would be attached to the defendant's application to adduce the statement of Miss Lapointe. But it's not on the active case record, so it doesn't go into the trial bundle. I think we're all agreed on that. Are we all agreed so far?
Yes, Your Honor.
Yes,
So it's not
yes.
it's not in the bundle.
It's not in the bundle. Good. Did you want to say something? Your hand is up. No. Okay. So I've looked, a large portion of the requests of the objections relate to documents that were attached to the revised particulars of claim, which was filed on the case portal on the 16th of October 2025. But according to my order of the 12th of December 2025, that revised particulars of claim was struck out. So that revised particulars of claim is not on the active case record for this matter. Yes, Ms. Amani.
Your Excellency, we accept that those particulars were not accepted by the court. However, for the case management hearing that was scheduled for 9th of December, there was a bundle produced and there was exhibits produced there again. So those are on the court bundle system.
They may be on the court bundle system because on the 9th of December, that revised particulars of claim was not struck out. It was then struck out on the 12th of December. So again, this is why I gave the example of Lapointe's statement. I may be able to look at the portal for this matter, and I may be able to find the documents, but that doesn't mean they're on the active case record. That revised particulars of claim was struck out. That includes not just the pleading itself, but also the documents attached to it. Now, I've reminded myself of what was ordered in that 12th of December case management order. After the amended particulars of claim was struck out, there was a milestone production of documents. So standard production of documents in accordance with RDC 28.15 shall be made by each party by no later than 4 p.m. on the 2nd of February 2026. Okay, that was the party's opportunity to disclose documents that they wished to rely on that were relevant to their pleaded case. Now, in the case of both parties, for the claimant, that will be the particulars of claim, not the revised particulars of claim. And for the defendants, it would be the defence. And if we look at Rule 28.15, each party shall submit to the other parties within the time ordered by the court all documents available to it on which it relies, except for any documents that have already been submitted by another party. Right, so that was the document production phase, at least the beginning of it. And then after that, each party was permitted to request documents from the other party. And we went through that phase and both parties had requests to produce documents. And I issued an order determining those requests. And I was guided by the parties' pleaded cases and what was relevant. And I said then, and I've said it before, that the key issue, it's not the only issue, but really the key issue that we have left to determine in this case is the quantum of the claim shares. There is also a claim for reputational loss by the claimant, okay, insofar as it's been pleaded, and the pleading is extremely sparse. It's said to be reputational loss following and flowing from the defendant's conduct with the claimed shares, okay, and not granting or rather deregistering the claimant's claimed shares. So that's where we stand. And so in light of that, many of the replies that have been issued in the claimant's reply skeleton, they all relate to documents that were attached to the revised particulars of claim, and they don't belong in the bundle. They're not on the active case record. They weren't then disclosed. I'm not sure the extent to which they're relevant. The second thing, yes, I'll come to you in a moment, Mr. Mon. The other thing I just want to emphasize with the trial bundle, when I looked at the reading list, and I don't believe the defendants have prepared a reading list, but the claimant has prepared a reading list. It refers to various page numbers in the trial bundle. The usual way that, certainly in the cases I've been sitting on in this call with the trial bundle, the usual way I see the documents in the trial bundle is each document is specifically named and labelled. So, for example, if it's an email from the claimant to the defendant, it will be described as an email from the claimant to the defendant, and there'll be a date given, so that if I am asked to read pages in the trial bundle, I know what I'm looking at. I was invited to read various documents in the trial bundle, and I've done my best to look at the existing trial bundle, but it's hundreds. I was invited to read, I think, 500 pages. Now, there were labels, I think, for the witness statements and the orders. Obviously, I'm already very familiar with the orders, and the witness statements were labeled, but then there's lots and lots and lots of documents, and they've been given very broad labels, like, I'm plucking a name from the air, Stallion Gates valuation. I'm not quite sure, where are these documents from? What do they relate to? Whose documents are there? I'm going to need more particularity in the trial bundle. So I just wanted to give those general principles first, and then we can go through what the remaining issues are. Yes, Mr. Mon, you wanted to say something.
Yes, Your Excellency. So in terms of standard production, we understood it that if documents have already been produced or disclosed at some point during the hearing, then we don't need to reproduce or redisclose them. And that's why, because we'd already disclosed them back in December, we didn't redisclose them on standard production.
I'm sorry that you misunderstood the court rules, Mr. Marnie. I mean, litigators who appear before this court normally would understand that if a pleading is struck off, it's not on the case record. So I'm sorry that there was some misunderstanding, but we really are where we are. And I have to say, given that the revised particulars of claim is struck off, I would need to understand what is the relevance of all these documents, given that we're focusing on the quantum of the claim chairs. There's all sorts of material referred to, like criminal threats. The other documents, I was sent a new volume 5 yesterday. I'm not clear on why volume 5 has been placed on record. I haven't looked at it carefully, but my understanding is that all of this is settlement negotiations, and it's not clear to me why those documents have been placed on the trial bundle before the merits claim. Again, the way, in my experience, it usually works is that when we move to the cost phase of these proceedings, then the parties may wish to rely on, without prejudice, settlement negotiations to say, well, we made an offer at such and such a level, the court has issued a decision at this amount, and therefore we're entitled to a cost. So I don't understand also why a lot of the material is on there. The revised particulars of claim material is one category. We can go through all the categories and all the objections, but I also don't understand volume 5. So why don't I, Mr. Galtcev wants to say something, but since I've touched on volume 5, I don't understand why we were given a second volume 5 bundle, but I'm not sure why this material is in the trial bundle. If you want to explain that.
Yes, Your Honour, I can go through the defendant's complaints one by one, if you would prefer.
No, I want to know why the volume 5 is there, Can you address that first? Not the complaint. We can go through the complaints one by one, but this is my question. Leaving aside the defendant's objections, my own concern upon looking at the trial bundle is I don't understand why all these exhibits relating to settlement negotiations are in the trial bundle.
Yes, Your Honour. So there's a couple of points on that. The first is we intended to make an application under RDC 4.21 to be allowed to submit that additional volume 5. In relation to the contents, there were items that were missed from the original bundle, which when we were going through the skeleton argument, we discovered that they were missed. For example, one of the court orders, and I agree most of it relates to costs. The main, I believe the main objection from the defendant is in relation to the letter before action, which...
Oh, hold on a sec. Hold on a sec. Let's go slowly, just so I understand. So volume 5, there were some gaps in the original trial bundle. That's fine, because I think where we have to get to by the end of today's hearing is I think we're going to have a fresh trial bundle, okay? And it's going to have to be specifically labelled, as I have said, so that we all understand what each document is, okay? And that goes more for the factual documents, or the hundreds of pages of factual documents, exactly what each document is. And I want to know in the index, which I would request you to produce first, I think it's important that it's specified when that document was disclosed. It's not going to work to say it was disclosed with the revised particulars of claim for the reasons I've already said, but it could have been produced with standard production, it could have been produced with a pleading, it could have been produced in response to a request for documents, okay? So we'll have to be given that information just to make sure that we don't have any further issues. And you can fill any gaps, any orders, etc. They can be filled at that point, okay? We'll talk about the letter before action issue in a moment. I don't fully understand it, but let's address that separately. I just want to make sure that we're addressing this point. Why is all the settlement material in there? Parties do rely on settlement negotiations in relation to submissions on costs, I've just said, but they wouldn't be produced at this stage before the merits hearing. Normally, they wouldn't be given to the judge at this stage, okay? They would be given once the judge has made the decision on the merits, and then the parties would mention their settlement negotiations. Now that I've made that clear, do you still wish all of that settlement material to be in the bundle, and if so, why?
No, Your Excellency, I agree with you that it relates to costs, and we can make those submissions at the cost stage, and we can put those documents in our cost bundle at that time. The only reason we put it in was because of the letter before action, and we thought we'd, for the sake of full disclosure, we thought we should put it in.
Okay, let's pause there. Okay, let's deal with this issue on the letter before action. I'm going to pause. You have your hand up, Mr. Galtcev.
Yes, Your Honor. From my perspective, it's difficult to imagine that the lawyers just don't know the basics of product production, and they just apply new materials after the deadlines. So, and you probably already, Your Honor, have seen how the bundle was structured, with tons of duplicates, with tons of not indexed materials. And if we are going to do the refresh bundle again, so it's going to take an enormous time for me just to have a look again. So that's why yesterday, Your Honor, you asked me to double check everything in the bundle. And yesterday I supplied like exact documents with exact, because previously you asked me to just narrow down to 2 pages. So and I just narrowed down like blocks, but there are a lot of documentations like exact number inside. So it could be like a block, specific block, and inside this block, the document that is not related to this block at all. So, and basically I just spent like yesterday the whole day to just have a look again, all this stuff. And I sent an email with all these numbers. I hope I'm right in terms of identification of all this, but basically it's a lot of work to clean this bundle now. And from my perspective, it's very difficult to imagine that just lawyers and professional lawyers, just they don't know how to structure the bundle. And what they say now is like, it's the first day in their work. So, and for me, it's like, it's very surprising that this is possible to producing the documentation with this documentation dump to defense in the last minutes and just do not try to get any leverage from this. So that's why like I just try to understand what is normal for the process production and what is not normal for process production in a court. Because for me, just it's also starting the process. It's first time I'm in a court like this, and I need to understand why it's normal and why. So like legal professionals can literally apply new documentation after the deadline and just file new documents that never disclosed before.
Well, the way I do understand the concerns, and I do understand that it's been very time consuming to go through the bundle, but with the process I have now suggested, where following our discussion today, and we are not finished, we do have to go through specifics, the claimant's going to produce a trial bundle index. It's going to be just an index at this stage, okay? And I don't think there's any issue with the witness statements or the pleadings. I don't think any of that is controversial. The real issues arise with all the volumes of documents, factual evidence, and there's also some video exhibits, which we'll talk about in a moment. And so once we have an index from the claimant explaining what each of these documents are and understanding that they have to have been disclosed and relevant, unless there's anything that hasn't been disclosed that they want leave to include in the trial bundle, which we can discuss in a moment, there won't be the settlement negotiations in. We'll talk about the letter before action in a moment, and there won't be the documents attached to the revised particulars of claim. So we shouldn't have any documents in this index for the trial bundle to be produced after today. There shouldn't be any documents that haven't been disclosed previously that we haven't discussed. Is that clear? So it's going to be much easier for you to understand and look through the index, and I'm going to suggest that the claimant sends it to you first, and then if there are no issues, that's fine. I'm also going to have a look, then the trial bundle can be issued. If there are issues, they can be raised. But again, we've got to deal with this all quickly because we still have a trial not very far away that we need to complete. Yes, Mr. Galtcev.
Yes, Your Honor. In terms of video links, so I don't have access to this now. So because it's limited, so I don't know why it should be limited. So, and it's never exist now, so I can't just download it. Second, all these video materials were filed after the second deadline. So we already were producing like all the documents. And I mentioned that something is missed. So in the terms of two transactions with Lechman and with Nikola Kozetic. And they also send the state of truth that all the existing possible things is done. And then just new files, video files appearing. And it's not just 1 minute files, so it's like 1 hour files. So, and I just try to identify where exact moment which is relevant to specific our case. Because I have seen the file where I just presenting the company for 1 hour, nothing, zero data about the valuation about the company. I was presenting the products of the company, and this also videos. So I had spent my time to look up these videos just to identify where is exactly
I
the
understand.
data I need to use.
We'll talk about the video exhibits in a moment. We're going to park that for the moment, and we're going to talk about this issue regarding the letter before action, which I don't follow. I understand that there's a dispute between the parties about this letter before action. Mr. Marnie, perhaps you could explain it to me, please. Thank you.
Yes, Your Excellency. That letter before action was it was in the December disclosure, which we now understand that it's not considered to be have been produced.
The October, you mean the October revised particulars of claim? Is that what you're referring to?
Yes, but it was uploaded to the system in December, on the 9th of December. There was a whole bundle. Yeah, there was a whole schedule of evidence that was produced at that time. I accept.
So that's all documents attached to the particulars of claim, is that correct?
No, it was for the CMC hearing. It was for the CMC hearing. There was documents attached to the particulars of claim, and then there was documents attached for the CMC hearing on the 9th of December. And that bundle is still on the court's bundle website.
Okay, what was the purpose of all these documents for the CMC hearing? Okay, I understand the revised particulars of claim documents. We've dealt with those. All these additional documents, why were they in the CMC bundle?
It was part of our disclosure for that hearing that we had prepared for. So that's why we understood that disclosure has been made. I accept what you are saying, that the particulars of claim was struck out. So therefore, any evidence that was attached to those particulars is struck out. The particulars did contain the evidence, and there was a link as well when we filed the particulars to a Dropbox. And the Appendix 1, Appendix 2, and Appendix 3, which is the videos, were attached there, but they were also separately attached again in December. So we understood that disclosure has been made, albeit in the wrong format.
Okay, so again, just so I'm clear, are you saying that there are documents in that CMC bundle that were not attached to the revised particulars of claim? And if so, I'm still trying to understand, because that was a case management conference. It was about setting down the procedure leading up to trial, etc., and talking about expert evidence. So I'm trying to understand, and excuse me if I've misunderstood. I think you said that there were documents filed with the revised particulars of claim, and there were additional documents in the case management bundle. What were those documents, and what was their relevance in the bundle?
The relevance in the October bundle was all the evidence that we were relying on in our claim. So we did.
Again, sorry, let me just try and understand this. I fully understand and follow that with the October 2025 revised particulars of claim, there are a lot of documents. I follow that completely, right? Yes. That was then struck out. It is not part of the claimant's case, and that includes the striking out of all the documents that went with it. Okay, we've discussed that. But I thought you said that for the bundle for the CMC, at that stage, at the time that bundle was produced on the 9th of December, that pleading was not struck out. It was struck out on the 12th of December following the CMC. What are the documents that are in that bundle that you wish to rely on that were not attached to the revised particulars of claim, whether as a link or otherwise?
The majority are a duplicate of those particulars of claim, but the particulars of claim had a link to go with them that was going to a Dropbox, and everything was there. That's when we submitted those particulars of claim. And then for the hearing, we had uploaded these documents separately as evidence that we wanted to rely on.
They're the same documents. I'm just trying to understand.
They are the same documents,
right.
yeah.
So there's no additional documents. We're still talking about the documents that are attached to the revised particulars of claim.
But disclosed in different ways. Yeah, but disclosed in different ways.
They were brought onto the record attached to the revised particulars of claim, which on the 9th of December was still on the case record. It was struck off on the 12th of December, right? So that means that that particulars of claim and all the documents with it, I presume, does that cover all the video files?
It does, yes.
Yes, okay. And just so I understand, since we're on the video files, can you remind me what the relevance is? I did try and look at the video files this morning. I've been given access to them. There's a lot of videos, quite long videos, and they all relate to Rail East. But just so I'm clear, and we're all clear, what is the relevance of those videos? There's a lot of them, so just you don't have to go through each one, but just so I understand, what is the relevance of those videos?
So the first relevance is obviously in relation to the defendant's conduct during trial, during these litigation proceedings. In terms of, I know we're not pleading defamation per se, but as in his conduct during the trial, so it's to assess damages.
Right, the damages,
the second...
let's look at your particulars of claim. Because again, I'm very worried that with this huge amount of documents in the trial bundle, their relevance has to be linked to the claimant's pleaded claim. And I'm sorry to interrupt you, but I just want to make sure that we're absolutely clear. We've got this trial coming up. It's a 2-day trial. We've got to keep things relevant. If you look at the particulars of claim, and I've reminded myself of it today, paragraph 48, okay, you're absolutely right. There is no pleaded cause of action in defamation. The breach it's paragraph 49. So there's a number of breaches alleged against the defendants relating to the deregistration of the claimed shares. I can call them the claimed shares because we all know what I'm talking about, right? And paragraph 49 says, as a result of the breach set out in paragraph 39 above, the claimant experienced foreseeable harm, including financial losses due to the inability to complete the sale of her shares, comma, emotional distress, which I know has been claimed, comma, and damage to her business relationships. The reckless removal of her shares and obstruction of the SPA with Buyer 1 led to the claimant incurring substantial financial and reputational damage, including the loss of future investment opportunities. Okay, so that's what's been pleaded. And then if we look at the particulars of loss and damage, there's a sum of $50,000 for emotional distress. Then there's $200,000 claimed for damage to reputation and loss of business goodwill. $100,000 of that is for loss of business opportunities, and $100,000 of that is impact on investor relations. Okay, so this is the pleaded case. So why are we looking, or why does the claimant wish to rely upon all this material relating to the defendant's conduct, etc.? I'm just trying to understand. We've got to keep everything relevant, yes. Okay?
Yes, Your Honour. So it's continuing conduct. So these pleadings were filed 2 years ago, and over the course of 2 years, that conduct has continued, and we wanted to demonstrate to the court that reputational damage and harm is continuing and hasn't stopped. And also under RDC 38.9, the court would consider when determining costs the conduct of the parties during litigation proceedings. So we do accept that 2 years ago that's where we stood, but this is 2 years later, and yes, there's continuing loss.
But the loss relates to, as a result of the breach, the claimant experienced damage. I'm going to cut out the unnecessary words. Damage to her business relationships. The reckless removal of her shares and obstruction of the SPA with Buyer 1 led to the claimant incurring substantial financial and reputational damage. So the reputational damage that's pleaded relates to the breach in her being deprived of the shares. That's the reputational damage that's pleaded. So I'm just...
Yes, yes, Your Honour.
I understand what you're saying about costs. Yes, it was 2 years ago, but that's what's pleaded. It's breach relating to the claimed shares. Okay, why don't you continue and tell me about the rest of the video? So one is about the defendant's conduct. And sorry, what was the specific conduct?
The conduct of continuing reputational damage to the claimant.
Right, but do you accept that the pleaded reputational damage, the claimant's claim in this court, in these proceedings, is for reputational damage arising from her being deprived of the shares. Do you accept that?
We do, and the videos relate to the same damage. So because she was deprived of her shares, the defendant posted certain videos online regarding those same shares and the deprivation of those same shares only in October 2025. So yes, in 2024, when we pleaded the case, this is where it stood. But in 2025, the defendant has created new videos and posts online where he has continued that reputational damage.
But that's not relating to the fact that she was deprived of the shares. I mean, there may be issues between the claimant and the defendants, but I'm trying to understand how they are related to the specific claim that's pleaded in these proceedings.
It
might be all contextual. It might be all contextual, and it may be all connected, but it still doesn't strike me as being related to what's pleaded.
The words in those videos specifically talk about this case and the shares and the revocation of the shares and the circumstances of the revocation of the shares.
Right, okay. Can you quickly run me through the other videos, and then we're going to hear from the defendants. Really, this just, I mean, I think I've already stated quite clearly, if these relate to the revised particulars of claim, they're not on the record. But just so I understand, because I've been sent all these videos, just can you quickly run me through what the rest of the...
And one
are
of
they
the
all
other,
the same? Are they all similar?
No, some relate to the claimant's position as a CEO, as a defendant continues to claim that she was not the CEO of the company, and she used that as leverage to be able to inflate the value, her position and the value of the shares. So some videos go to that claim where she is clearly being promoted as the CEO. And one of the other videos relates to Victor Lechman attending an event with the defendant because the defendant had claimed that he doesn't know who Victor Lechman is, he's never heard of him, and it goes to the valuation of the shares. At that event, the defendant was making a presentation about the business and pitching for investment. And Victor Lechman was present at that meeting, which is all recorded on one of the YouTube videos on the defendant's channel.
Right, and so your submission is that that video is relevant to the issue that the court has to determine, which is what is the value of the claimed shares, the video of Mr. Lechman and the defendant somewhere.
Yes, because Victor Lechman obviously relied on certain valuation documents that were produced. Those documents were produced at the same time that this video was produced. So our submission will be that the documents that Victor Lechman relied upon to determine the value were the defendant's own documents that were presented by him on that event where he was present and did meet the defendant, which the defendant then later denied ever knowing who Victor Lechman is.
Okay, yes, Mr. Galtcev.
Thank you, Honor. A lot of things to answer. So, first of all, I reject all of this. So, in terms of...
By the way, can I just remind everybody, we're not giving evidence now. I don't need your evidence
sure.
on the Victor Lechman videos. I do not require evidence. We will deal with that when we have the trial, okay? I'm really just trying to sort out the trial bundle, and I just want to remind you of that. I'm concerned that we're going to get into some rabbit hole discussing all of this material in detail, and that is not necessary, but I will give you an opportunity to respond very briefly.
Your Honor, I'm in the same page. So it looks like it's still like documentation, like a dump and junk, a lot of documentations and videos just to escape the main thing of the process, the main issues of the process. So there's two transactions. So all these evidences were first presented after deadline. So I really don't understand why we spend so much time on something that presented after all deadlines and disclosure of everything. So I don't understand why. Second, my objection is that once somebody tells that I have a video that one guy on this video and another guy on this video and they connected, I was presenting people, like hundreds of people in the room. I didn't know everyone in this room, whatever they are on the video or not. So it's like a lot of small things that not relevant at all in terms of the main issue of the bundle, main issue of the court sessions. Sorry about my English, I don't know how to explain, but we just burned already in a lot of not relevant information, and we're still not even close to bundle and just understand what's relevant, what's not. And we are 2 hours, not 2 hours, 1 hour already in this thing. So it's going to be never ends. So I just welcome the court just to focus. We are all focused on something relevant to the real production. Thanks, Your Honor.
Okay, so let's leave the video evidence for the moment. Ms. Amani, I think I'd asked about the letter before action, and I still don't think I've got to the bottom of that. So may I ask you please to address that?
Yes, Your Excellency. So the letter before action has been previously disclosed, but it's not on the record now because those particulars of claim have been struck out. But it relates to the defendant's claim that the shares should be restored back to the proper remedy is restoration of the shares rather than a monetary claim. Our position would be that the claimant did request restoration of the shares prior to issuing proceedings, and that was a request that was denied at the time, that has resulted in this 2-year-long battle to prove that she owned the shares. Everything is denied by the defendants. Every single document is put to proof, and that's why everything has taken much longer than it ordinarily should have. So that's what that letter before action goes to, and Your Excellency will note that the defendant has said that he never received that letter before action, and so in bundle 5, this is where we would request that we can add this document to the court record, if you are so minded. There is evidence of an email sending that letter before action to the defendant, and there is evidence of a telegram chat as well, sending that document to the defendant. And it's our duty to make sure that the court is aware of the facts, especially when the defendant puts us to proof on every single document, saying that it wasn't received by him. He's never seen it before, when he clearly has, and that's why we would request that that is allowed into the bundle.
Right, but my recollection, I can check, is that the claim form asked for the shares back, and after issuance of the claim form, the shares were not returned. So do we really need the letter before action?
The original claim form that the claimant issued, yes, it did. And then we put in a revised claim form because that was after the event, after all the deals had been cancelled and monies had been returned. Then we didn't want the restoration of the shares. We wanted a monetary claim at that point. So the original claim form is not in the bundle, as far as I am aware. The original claim form that the claimant submitted herself is not in the bundle, but it is on the court record.
I'm fully understanding what the issues are. I think we can manage. There's no need for us to have a big fight about the letter before action. I mean, really, if we look at this situation, we are 2 years on, and it's clear to anybody that there's a highly acrimonious relationship now between the claimants and the defendant, and one questions whether restoration of the shares to make the claimant a shareholder in this company is going to be a very good outcome. So leaving aside all the other issues, I think we can manage without the letter before action. Mr. Galtcev, you wanted to say something?
Yes, Your Honor. I would like just to show you what's in the bundle just in a second.
Can we please go topic by topic? That's going to be much easier for me.
Yes,
I'm still dealing with the letter before action. Is that what you wanted to address, the letter before action?
Yes,
Can you
Your Honor.
address me without us having to look at the trial bundle?
Yes, but I try, but I can't share the screen. This is a technical. Can you?
Don't worry.
Are you
Yes.
able to see it?
No, I don't. Why don't I've got the trial bundle. I can look at it if necessary. Why don't you let me know what the point is?
So
you'd like to raise?
exactly, it's near the end. It's 1,300 something pages. So it's near the end at volume 5. They presented the letter without any sign of messaging. It's just a Word file. And not just this information presented as approved in this kind of structure. So it's a Word file without any signs of any send to anyone. Then in the new bundle, so that they sent like 1 hour ago, I just briefly checked. They just put 2 pictures, like a screenshot of the Telegram chat with the documentation attached, the same naming of the document, and document without any signs. So how they're going to prove that it's exactly what they show is exactly inside the chat?
Understood. I think we can manage without the letter before action. That deals with that. Okay, so we're not going to have the letter before action. Ms. Samani, did you want to go one by one through the objections? I have read the claimant's reply skeleton. Now that we've dealt with the documents attached to the revised particulars of claim, I think that's dealt with most of those documents. So I think perhaps we could address what's left. I'm just trying to find yes, I've got in front of me the claimant's response to the defendant's objections.
Yes, Your Honour. So the defamation exhibits, I think we've already discussed. The defendant's objection was that these are irrelevant, and in the defamation letter that was produced as well is irrelevant and it should be removed. We've explained that the order of the 30th of April was a request for production. As we had assumed that those documents had already been disclosed back in December, we didn't feel that they needed to be produced again, but we've discussed that. So that point has already been dealt with. And the relevance was in relation to continuing conduct towards during proceedings. The second complaint related to Stallion Gates exhibits. These documents were again in the December, for want of a better word, production at the time.
They were attached to the revised particulars of claim in October, correct? Not
yes,
December.
Yes.
Or December.
In December, yeah.
What are the Stallion Gate exhibits? What are they?
So the defendant originally claimed that he didn't know who Stallion Gates were, and this is also in Nicola Kosutik's witness statement, where he says that the defendant had told him that he doesn't know who Stallion Gates are. There's been no valuation by them. Then we produced these documents in evidence that there was a meeting between the defendant and Stallion Gates, and where they were discussing valuation, we assume, because we don't have control of the full documents. Those are in the control of the defendant. And despite having been ordered to produce those documents, or all documents in his possessions, those documents were not produced by the defendant. and instead the defendant did produce a witness statement from a totally different entity, Stallion Gates USA, not Stallion Gates UAE. The person that he had met was Mr. Shafat Hashmi, and that's why the LinkedIn post is there to show that he was the head of Stallion Gates UAE. And there was a Telegram message. So those were the two documents relating to Stallion Gates. It was a Telegram message of a meeting that same day. And then there was the LinkedIn post of Shafat Hashmi to evidence that he was who he was. Because in Nikola Kosciuszyk's evidence, he said he'd said that this friend had told him he doesn't know who they are, he's never met them, doesn't know anything about them. So it was in relation to that.
Okay, I've just had a quick look at all of the points, and it looks as though all of the documents, we've dealt with the pre-action letter, and all the other documents were documents relating to the revised particulars of claim. There's something in paragraph 58 about volume 5, but a lot of that is settlement material, which should not be included in the trial bundle, and some material following on from the revised particulars of claim. So in a while, I'm going to just take a short break for you to let me know if there's anything left, because I think actually when we've dealt with the revised particulars of claim, the settlement negotiations and the pre-action letter, it's not clear to me that there's anything left. But before we do that, I'm going to hear from Mr. Galtcev. Yes.
Thank you, Your Honor. I think a lot of left, so in the bundles that we need to discuss. In terms of this Stallion Gates, it were added after all disclosure twice. So it's new materials. Second, nothing showed Stallion Gate. They showed the name Shafat, and he was presented to me as a private investor at that time. And I had no communication, so it was presented by my lawyer, Denis. So I even didn't have any contacts with this gentleman. We had one meeting which was scheduled by the claimant. And that's why
I feel that we're veering into evidence again, Mr. Galtcev.
No.
I'm sure that we will traverse all this material during the trial, but thank you for clarifying. That is very helpful, and we can certainly look into this further during the trial, but thank you for the clarification. I understand your point about some of these documents not having been disclosed, but hopefully if the way that we proceed is to have a new index prepared with each document referred to separately. So rather than having Stallion Gate exhibits, we'll have a description of each document and then the date of the document as well as the date it was disclosed. Presumably it should be very straightforward to ensure that we're putting into the trial bundle material that has been disclosed in accordance with the milestones of the court. Does that address any concerns?
Yes, Your Honor, that's fine. That's only one thing. I just want that we're in the right process. Thanks.
Okay, all right. Ms. Oni, should we take a short break? Do you want to check whether there's anything else that we haven't dealt with? Why don't we have, it's now 1:05 p.m. UAE time on my clock. Why don't we reconvene at 1:15 and we can see if there's anything else remaining. Otherwise, we can discuss which directions need to be handed down. Okay?
Yes, Your Honor. There was one point
Yes.
that I was to make. It was just in relation to the production of documents.
Yes.
If the judge is minded to say that all the documents that were produced back in December fall away with the pleadings that they were attached to or in relation to, then we are scant on evidence on our side. But when there was an order of July April, where production was required by the defendants, and that production hasn't been carried out because there was clearly a valuation report that the claimant's expert report relied on, and that hasn't been disclosed. In addition, all the materials that the witnesses rely on in relation to meetings that they say the defendant was at where valuation was discussed, those meeting notes or minutes were not disclosed. The Stallion Gates material was not disclosed by the defendants themselves. The claimants assumed that they had produced them, and that's why they didn't reproduce them. But the defendants didn't produce those documents. They didn't produce any of the documents that were attached to the that were given to the valuer the expert valuer in the valuation report. So we would request that Your Excellency makes an order that those documents are produced. That's something we could consider.
Right, I understand what you're saying. I do understand that. Let's sort of map this out step by step. Okay, so the key issue at this trial to be determined is the valuation of the shares. I've read all the witness evidence. The claimant's witness statement relies on, in relation to the valuation of the shares, 2 spreadsheets, right? And so presumably the claimant's position is, this is the valuation of the shares based on this financial data. And it would be usual, one would expect, that if one was valuing a company, one would want to look at the financial data. That would probably be one of the key components in valuation. So I do understand what you're saying about there being scant evidence, but presumably the claimant does rely on financial information as well as her pleaded case, which is the 2 transactions, correct?
Yes, Your Excellency, and that's why we tried to keep the matter simple. It's only when we get allegations that this wasn't disclosed or this was related to something else, we won't have the evidence to be able to counteract those allegations that come from the defendant during the trial.
It's your case. It's your case. You're the claimant. You represent the claimant. The claimant has to prove her case, and she has to establish the value of the shares. Given the evidence that you have produced these spreadsheets. I think they will probably need more explaining at the trial. We can get to that when we get to the trial. There is the share transactions, and there are other documents on the record, so far as I'm aware. So I hear what you say, but I mean, where are those spreadsheets from? Presumably the claimant heavily relies on those. I hear what you're saying, but it just strikes me that a lot of the avenues we are going down are not relevant to this key issue. Even if we talk about videos or many of these things, I mean, some of the material, criminal threats and all kinds of things, we really have to keep ourselves on track on the valuation evidence. Now, in relation to the claimant's request, I understand the request has been for various financial data. There was an order issued in April, as you have reminded me, and that ordered the defendant to produce various documents. Now, the way it usually works is if an order is issued and documents are not produced, it is open to the opposing party to invite the court to draw inferences or adverse inferences by the absence of documents. And I also understand that the defendants actually don't rely on the expert report. And I know that the claimant will wish to make points about that. There have been some points raised already. So that there's still quite a lot there. Even the absence of documents can be relied on. I'm just not keen to make any further orders at this juncture. We are literally on the eve of trial, and we're trying to get this case and the documents in good shape so everything's clear. And as we all keep saying, it's actually fairly straightforward what needs to be determined. Yes, Mr. Galtcev.
Yes, Your Honor. So from my perspective, it's clear the strategy to go out of the main points. And once the claimant tells that it didn't was produced, so I signed the statement of truth, and it means something. So after all disclosure, all disclosed, and I exhausted all searches. I did everything that I could just to present all materials. On the opposite side, the claimant signed statement of truth twice that exhausted all searches, and new materials coming and coming and coming related with your owner order to disclose materials for this matter. And I just don't have enough time to read all of them.
Right, but we've already dealt with how we're dealing with the documents, right? Yes, Ms. Samani.
Your Excellency, just on that point, there was a clear order for production, and there were documents that were disclosed to the valuer. They are listed in the valuation report, and they were not produced. So the production statement would be inaccurate.
I understand. I mean, I agree completely, and I think it's very clear in the rules. If a expert report refers to documents, those documents have to be attached to the report. I mean, that's just, it's a matter of common sense as well as the way that things work procedurally. So I'm not sure why those documents were not produced. They would have been extremely helpful to look at the valuation, but I understand that defendants don't rely on that expert report anymore.
Your Honor, these documents were produced before you ordered for extra disclosure. It was produced with all the screenshots of my communications that time, and the name of all this document is like valuation between April and July, if I remember correctly. That's what they declare. So all the screenshots, it's inside the disclosure moment with all audited financials. It's the same document. So they rely on some and the same documents were presented to estimators. So it was disclosed. So they haven't.
Where are these documents? If you took us to the case portal, could we find them?
Yes.
Okay, we'll pause there. Yes, Ms. Amani.
Your Excellency, the expert's report was produced on the 19th of May, and the production statement was produced by the defendant on the 5th of July. And therefore, there was no reason why the defendant could not have produced the additional documents or supporting documents for the expert's report at that point.
So I think he's saying he did produce them. That's what we're trying to get to the bottom of. Sorry, yes,
are you able
Mr.
to see my screen?
Yeah. I can see a screen. I don't know whose screen.
Are you able to see the? Are you able to see the screen like the IFC court portal?
Yes, but
okay.
That's not your screen, is it, Mr. Marnie? You just took us to that screen as well, didn't you?
No, I've not gone onto the screen. No, Your Honor.
Oh, right, it's you. Okay, yes.
Are you able?
Mr. Galtcev, yes, I can see that.
Are you able to see Anastasiia Denisova versus
yes.
Aleksei Galtcev? Yeah, good. So this is the expert report, 9th of May.
Yes.
And this is the 8th of May. So this is a defendant's production statement, and this is appendix. And inside this appendix, the documentation they ask. So it's exactly these files that were presented. 41 pages, that's already in the bundle. This is exactly what we have. All this materials.
This is what you gave to the your expert.
Yes, Your Honor.
And there's no other documents that were given to the expert.
No, Your Honor.
That was it.
Yes.
Okay. Yes, Miss Amani. I'm not familiar with those documents, but we're told that those are the documents.
I believe there were other documents there that were mentioned in the report. I will check during the break if that is covered by the report. But there was a long list of documents that were produced to the expert, and he scheduled those. So even if some are included there, it can't have been all of the documents, because there's a long list of evidence in the expert's report.
Right. In any event, those documents that we've just been taken to by Mr. Galtcev, are they in the trial bundle or going to be in the trial bundle? It's some valuation material. I'm not familiar with it, but if it's relevant, it can be adduced at the trial and relied on by either party.
I can check with Alice, my assistant solicitor who created the bundle, if during the break, and we can come back to you on that point to make sure that that evidence is in the bundle already.
I mean, really, all the evidence that's on the active case record, if I can put it that way, it should just go in the bundle. You can include the document production statement, because it's incumbent on the claimant to make sure that the trial bundle does include all the relevant documents. Yes, so
I assume it is.
Okay.
Yeah, I assume it is, but I don't want to make a misrepresentation, so I'll check with Alice and revert to the court.
Yes, Mr. Galtcev. Okay, right. It's 1:16 p.m. Why don't we have a short adjournment? How long do you need, Mr. Marnie? I don't want to rush you.
Would you suggest 20 minutes? Yes. Okay.
Okay. Let's just give you till 1:40 p.m. So we're checking if there are any other issues. Sorry, any other issues needing to be addressed now that I remember, sorry, I've seen the response. I think most of this falls away because those documents were attached, the revised particulars of claim. I'm actually, before we adjourn, let me just see if we've dealt with the objections. So number one is the duplicates. And then there's a lot of queries about documents, such as an undated letter, request to remove company references, screenshots of folder listings. Again, once we have an index in the format that every single document is named and dated, and we have a clear date for when it was disclosed, I think all of this should fall away. There are some requests for redaction. I'm happy for Emirates ID numbers, residential addresses, and personal phone numbers to be redacted. It's not necessary for them to be included. And there was one concern. There was a chronology of WhatsApp messages or Telegram messages between the claimant and Mr. Kosutev. And I understand the defendant's concern is the messages can speak for themselves, but I think there's a description that's been provided.
The description was to assist the court to understand what those messages related to, but they're not contentious in any way.
I mean, I've seen them because I looked at them when deciding the Lapointe statement issue. I mean, we can have them removed if you wish, Mr. Galtcev. I've looked at the messages. I would rely on the messages and the evidence itself. But if you feel strongly, we can have those removed. I've already looked at them, but if you want, we can have. If you want, in the new iteration of the trial bundle, all of those descriptions can be removed. Why don't we do that? Just out of fairness,
yes.
Just remove those descriptions. That's fairest.
We will do.
Then I think the defamation, Sallian Gate. See, Exhibit 5 was in disclosure. I found that in disclosure, so that the actual disclosure. I think that's it. And then a lot of issues about duplication. What about the data room material? Where is the data room? When was the data room material first disclosed?
It was again disclosed in December, and that was again disclosed there.
Okay. Right. Okay, it's exactly 1:20. We're going to adjourn till 1:40. Sorry, Mr. Galtcev, did you want to say something?
Yes, Your Honor. after the break, we're going to continue with all this, or it's finished?
No, you can still address us after the break. Mr. Marnie is just checking, firstly, about the valuation documents, and also now that we've already discussed and set out what the parameters are, what else might be remaining? And I've tried to do that as well. I think we've covered everything. Why don't you reflect over the break and just check that whether what we have discussed and what we have agreed about the trial bundle index going forward is going to resolve all the issues. That will be helpful. Okay.
Thanks.
So I'll see everybody at 1:40 p.m. Thank you very much.
Thank you, Your Honour.
Are we ready to start again? Yes?
Yes, Your Honour.
Wonderful. Why don't we start with you, Mr. Marnie?
Yes, Your Excellency. So in relation to the appendices, they are in the bundle. I've confirmed that. They're in volume 2 at page 121. Do they cover all the documents that were disclosed to the valuation, to the valuer, and are listed in the valuation report? We submit that they don't. There's a long list of documents there, and those appendices do not cover all the documents that were provided to the valuer. So there's a clear production issue there.
Okay, well, you can make whatever submissions the claimant wishes to make about that at the trial. Okay, just let's make sure, because we're going to end this hearing with a new trial bundle index produced. It should include all documents attached to pleadings. There may be documents attached to witness statements. I'm trying to recall documents that were disclosed according to standard production, and then documents produced in response to requests for production. Just make sure, obviously, that both sides' documents are included. But yes, whatever submissions the claimant wishes to make can be made in due course. Yes, Ms. Marnie.
Yes, Your Honour. In relation to the disclosure that was made as part of the struck out amended particulars of claim, I would like to make a short submission, if Your Honour would permit.
About what? I mean, we had standard production of documents in February. If we look at standard production, it should actually include all the documents a party wishes to rely on. So anything that the party that wanted to be relied on could have been produced then. And I cannot recall offhand all the details of the amended particulars of claim, but we're very late in the day now. We need to have a trial bundle ready. We've got the hearing in just over 2 weeks. We need to have this claim heard, and it's actually fairly straightforward. If you want, you can make some submissions. Don't want to shut that out, but you know, we have court rules. They're available for everybody. You have to read them. But yes, please, I'll let you make very short submissions, but I think I've made clear what I think the right course is, but I'll let you make very short submissions.
Yes, so it's our submission that the fact that the particulars of claim were struck out does not strike out the documents that were produced. The particulars, the striking out the particulars strikes out the document that the particulars were written on, but not the documents that were produced pursuant to those. During the short break, I was trying to look for a RDC rule or a previous case law that would support the court's position, but I couldn't find any rule in Part 28, in Part 4, or anywhere else in the RDC where it says that striking out the particulars strikes out the documents that were produced. In addition, and
can I just confirm, all those documents were attached to the particulars of claim as exhibits, is that correct?
They were attached to the particulars of claim, and then they were submitted separately as well on the portal prior to the CMC in December. So there was
the CMC bundle. All it does is it gathers together documents that are audio on the record. It's just like the trial bundle. It's not a vehicle to introduce new documents. It's just a compilation of documents that are already there. So is your submission that the they were introduced via the CMC bundle, and that's why they should be.
Our submission is that the fact that particulars of claim have been struck out, that the attachments that were used to disclose that disclose certain documents are not all also struck out at the same time. They stand as having been produced in evidence, and the ongoing duty for production. And the order of April for production was very plain in that it said that documents that have not already been produced or disclosed to the side, so they had already been disclosed, they had already been produced, or let's say disclosed, they'd already been disclosed, and therefore on the plain reading of the words is our submission that they didn't need to be reproduced. And in our counter arguments during the production order, we did put that in the Redfern schedule that these documents have already been produced, so therefore they don't need to be reproduced. And there was no counter argument to that statement at that time. So therefore we submit that we were entitled to rely on that that fact, that there was no objection or concern to have them reproduced because they had already been produced. In any case, the RDC Rule 28.15.1 itself recognises prior submission, and it states that standard production.
Let's take this step by step. RDC 28.15. Have you got it in front of you? I'm going to read it out again. I read it out earlier, but I'm going to read it out again. It says, within the time ordered by the court, so in this case, it was the 2nd of February 2026, each party shall submit to the other parties, number 1, all documents available to it on which it relies, including public documents and those in the public domain, except for any documents that have already been submitted by another party. So that's what it says. Which is the part in 28.15.1 that's relevant?
Just going to read this, Your Honour.
Okay.
Your Honour, we submit that it's the part that says except for any documents that already have been produced or submitted by another party. So therefore we submit that they were submitted in December. They were submitted in October as part of the amended particulars.
By you though, not by another party. I'll leave you. I can tell you're discussing with your team. Let me just leave you for a moment. Why don't you consider that? It says except for any documents that have already been submitted by another party. Why don't you consider that for a moment? I'm just going to hear from Mr. Galtcev, who has his hand up. Yes, Mr. Galtcev. Yes. Oh, you're on mute. Mr. Galtcev, yes.
Sorry about it, Your Honor.
Yes.
So I just want to ask about step back in terms of the documentation that was not produced or not disclosed, and the claimant side tells that it disclosed it with appraisals, right? Is it possible? It was a question of that the documentation wasn't disclosed at what given to the appraisals. I just want to ask, it's about appraisal report. It's about expert report.
Sorry, the expert report. Sorry, I missed
Your
that.
Honor,
Right.
I'm super sorry.
No, not at all. It's just my misunderstanding. The documents that were referred to in the defendant's expert report, yes.
the claimant side tells that it's clear that documentation not presented as a disclosure. Could I get the list of exact what is not disclosed? Because from my side, it's clear the same documentation that I presented on disclosure. So, and couldn't be a separate section. So not in a, as soon as possible. I mean, like, because if we are going to jump into the production again with a new, and they tell that some documentations didn't produced as a disclosure process, I would like to respond on this separately as fast as possible. So we are going to have the right bundle, because it's again,
it's referred to in the expert report. Do you have a copy of the expert report? I believe that there's a schedule at the end of the expert report which sets out a list of documents. If I'm not mistaken, this is from memory, but I'm sure Mr. Marnie can help us on this.
It's in a bundle. Probably we can do it on this session. If it's going to be very fast, yes, it's going to be faster. Yeah, sure. That I just show where this documentation exists, because and if Mrs. Moni is going to be so helpful and tell us at what page they have an expert report and exact materials that were presented.
Okay, let's deal with one thing at a time. I think we're still dealing with her request to have the claimant's request to have the documents exhibited to the revised particulars of claim added to the record. Yes, Mr. Marnie. Oh, you're on mute.
Okay,
yes.
Your Excellency, yes, thank you. And thank you for allowing me some time to reconsider that. So part 28 does indeed say, except for any documents that have already been submitted by another party, it does say that, but Part 28 does not say, and nor does Part A, does it say that disclosure is expunged upon strikeout, and there's no DFC or English authority that supports that proposition. Disclosure is a party-level continuing obligation and doesn't travel with or perish with any particular pleading. The correct approach of the court would be in a case that I've been provided with by my team, being Swahini versus Credit Suisse, which reflected that the orthodox position is that which reflected the orthodox position that the consequences of a struck out or abandoned pleaded claims are addressed through the case management and costs and not through the evidential expungement. Therefore, in the alternative, if we do request that those disclosures are not expunged from the court record.
They're not on the court record. You want them added to the court record. They're not on the court record. As far as I'm concerned, they were attached. They were brought onto the court record, unless I'm mistaken, by virtue of being attached to the revised particulars of claim. That revised particulars claim has been struck out. So it's not on. I mean, it's on the court record. It's on the portal, but it's not part of the active case record. The current pleading for the claimant is the original particulars of claim and not the revised particulars of claim. And so those documents, they're not on the active case record. I understand what you say, that they were included in the case management bundle, but that doesn't bring them onto the record. The bundle is just produced for the purposes of the case management hearing, and it just is compiled through documents, and the obligation on each party is to produce the documents available to it on which it relies in 28.15, for which there was a milestone. I'm happy to look at the case you have relied on. You'd have to file it. I'd be surprised if it changes my view, because I'm struggling to understand how, if the revised particulars of claim has been struck out, how all those documents, the vehicle through which they are on the active case record. Why don't you, instead of us wasting lots of time on this, you can look at the case, you can even screen share it, we can look at it in case it's a proposition of law that does assist the claimant, but just my understanding of the rule
Yes, Your Honour.
suggests that this is how it works.
So our position is that the striking out of the particulars doesn't strike out any evidence that was attached to it. The evidence was disclosed, and it has been disclosed. And on a basic reading of the, a very simple reading of the production order, it said that documents that had not been previously disclosed, and we submit that they had been previously disclosed, though they were attached or relevant to the case management proceedings that were dealing with the amended particulars, they were disclosed in any event. And our position is that because they were disclosed, they were not required to be redisclosed. However, the court does have the power under RDC 4.51 to remedy a defect or irregularity regarding the disclosure that has been already made. It's not that the defendant has never seen it before, or the court hasn't seen it before, or that it wasn't disclosed before. There's a procedural irregularity that we invite the court to remedy. Right, and I could provide my notes to the court after today's hearing before the court makes any directions.
Right, but the Redfern schedule that you're referring to, when it says documents already disclosed, I mean, the court's not sitting there looking at the whole court record. It's just saying these documents are relevant, and if they've not been disclosed already, they need to be disclosed. The court is not sitting there with the whole file open, looking at what has been disclosed and what has not been disclosed. It very much relies on the submissions that are made about what's relevant and what should be produced and what may or may not have already been produced. I'm not sure you can rely on the request to produce and the fact that no objection was made to a reference to documents previously being disclosed as an avenue to allow the documents that you want onto the record. Let's leave it there for the moment. Yes, Mr. Galtcev.
Your Honor, I don't have any questions.
Sorry, I thought you had your hand up. Okay, Mr. Galtcev has asked about you wanted to look, Mr. Galtcev, at the expert report and the schedule of documents that's attached to the expert report.
Yes, it's in volume 2 and page 121 or thereabouts.
I'm sorry, what page?
Around page 121, I'm going to just find the exact page number. The exhibits were in volume 2 that were attached to your disclosure. Let me just find the exact page for the evaluation report for you. Volume 2, page 212, I believe.
Is it possible to give a number when you download the bundle? So
I can try and find that.
It's not by volumes, it's just pure number.
My assistant is just trying to get to the volume and see if we can find the court paginated number.
Please.
I'll wait for that. I'm also trying to look for it, but that's why I think it will be helpful when we have I don't know if we can have one volume, but just a very clear index for each volume will be helpful. And also, I think there's that happens sometimes. There's 2 different numbers.
I believe we'd paginated the volumes that we'd uploaded, and then the court system repaginated.
That happens sometimes. I think that does happen.
Your Honor, I suppose it's the page 597 in red. That's
okay.
What claimant would like to rely, but I don't know. So what?
Okay.
what they would like to rely on.
Oh, right. That is, have you got that open, Mr. Galtcev? I think it's page 596 to 597, and that's the red numbering.
Yes,
trial bundle.
596. I see it.
So this is the push digits expert report, and then they have source references and evidence register, and then source financial data inputs, derived source ratios. Sorry, that's the source is financial data inputs, things like investor presentation revenue, etc. I think those are the documents we're referring to, Ms. Amani.
Yes, Your Honour. So page 577 in red, it says summary of attachments reviewed, audited financial statements for 23, for 24, year ending 24, financial statements again for Realist Technology for 23 and year ending 2024, Magic Flash, estate, real estate or brokers, all these schedules there. The SPA, we have a letter of intent. We don't have the actual share purchase agreement for Fedor Rubstov.
Okay,
Yeah,
let's pause there.
All of those documents, really.
Mr. Galtcev, can you see this? It's pages 578, so 577 and 578.
Yes.
Right.
Yes,
So
Your
I think
Honour,
it's
and
those
all this.
documents. Yes.
Yes, Your Honour, all the documentations already in the bundle and supplementary bundle. And once I was offering them to add this documentation inside the bundle by few messages because it was disclosed.
Okay.
It's already in the bundle and supplementary bundle.
Right.
Financial audited reports, all presentations, everything. It's already inside the bundle.
Okay, Miss Amani, have you been able to locate these documents in the bundle?
Yes, Your Honour, that was one of the points that I wanted to raise as well. My team has advised me that the supplementary bundle was never provided to us or uploaded to the court portal by the defendant himself, and it was never provided to us. That is what I am advised.
But I've downloaded it from the court portal. I downloaded it last week.
The supplementary bundle, I was looking at it here in the list here. I see I'm on the court website right now, and
go to trial. I think there's a section case bundles.
Yes, we're looking in that, and we see the trial 27th of July 26, and yep, and then we click on this, and there's only the one bundle that we can see.
Mrs. Amani, you need to click share it with me button.
Share with me.
Share it with me button on the top.
Share bundle. This will share the bundle that is there, right? To no, okay. Share bundle.
The portal shows only your bundles that you filed, but if somebody filed like the opposite side files the bundle or supplementary bundle, you need to find it on the behind the button shared with me.
Oh, shared with me. Shared with me.
It was also my problem that I was trying to find the bundle, but I discovered that it's under the button shared with me. So it's shared and it's filed. And also all these materials which inside the supplementary bundle, I send you with letters separately once you were making production of the bundle. I basically shared all materials with the PDF ready. And I told on email that this all documentation that I was asking to include you twice, and you didn't include it in the case bundle. I just package it in PDF, send you with the email, and also send you that this is a link for all financial statements audited. So it's already inside.
Are there other documents? So the supplementary bundle you have already referred to. On disclosure, is it possible that you have disclosed documents that the claimant has not had access to? Where did you, all the documents that you've put into the supplementary bundle, you
Yes.
say you've disclosed previously?
Yes.
Right, and does it include all of these documents that we see on pages 577 and 578?
Yes, correct.
Okay.
Your Excellency, can
I
I
welcome
consult
claimant.
with Alice? Who's,
Sorry.
can I consult with Alice, the solicitor who prepared the bundle and was dealing with the defendant in relation to the documents for 1 minute, please?
Please,
He
5
is
minutes,
on
but
the link as well.
before we adjourn,
Yes.
sorry, for 5 minutes, Mr. Galtcev, did you want to say something else? I see your hand up.
Yes, Your Honor. I welcome claimant to show exactly what's not included. So because it's going to take a lot of time again.
Yeah, no, just take 5 minutes, look at the bundle, access it. Let's see if it has everything that you're referring to. Okay?
Yes,
We'll
I see those
reconvene.
documents in the bundle, but I'm not sure if they have been previously disclosed. So I will check with Alice, who was liaising with the defendant.
So is it possible, I'm not familiar with how the court system works for parties. Is it possible that you needed to look behind shared with me for disclosure as well? Well, I'm going to leave you 10 minutes. We'll come back at 2:15. Please review the supplementary bundle and consider whether they have been disclosed to previously.
Yes, Your Honour.
Even if they're not, you had requested the court to order the defendant to produce these documents earlier, if I'm not mistaken. But anyway, we can deal with that when you come back.
We had, yes. Yeah.
Okay.
Thank you.
Are we all ready to reconvene?
Yes, Your Honour.
Mr. Galtcev, do we have you? Okay, yes, Ms. Samani.
Yes, Your Honour. So my assistant has looked at his records and he can't find any emails serving the documents prior to the 7th of May. But if we are wrong, then we invite the defendant to show us because we can't find that on our system. 7th of May, just to remind the court, was the date that the production statement was, apologies, the production statement of the 5th of July was the production statement that the defendant signed. And we can't find anything prior to this date having been served upon us or added to the court file by way of disclosure on the court file. We do note that the supplementary bundle was shared on the 22nd of July. And that was the day that we filed our skeleton argument with our complaints saying that those documents were not disclosed. And on the same day, we can't tell the time on the court system, but they were shared on the same day. So we, based on what we have, unless the defendant can show otherwise, the inference would be that they were shared after our skeleton argument complaining about those missing documents was made.
But Ms. Amani, you're aware of my directions. Once these issues arose between the parties about the trial bundle and the defendants complained that a lot of material was not in the trial bundle, I issued a direction that skeleton arguments were to be filed on the 23rd of July and the defendant supplementary bundle was to be filed on the 22nd of July. So I believe the defendants had already raised concerns about documents not being included. So I think that deals with the last point. I didn't quite follow. You said that nothing was filed before the 7th of May. Are you saying it was filed after the 7th of May, or are you saying it's not been filed at all, or you've never received it? Because I wasn't sure what the reference was to the 7th of May or July.
So what we are saying is that on the court record of documents or case events, we can't see any documents having been attached. And Ellis, my assistant solicitor, has said that he doesn't recall receiving any documents, but he would need more time to check. But if the defendant is aware that he did send those documents before his production statement of the 5th of July, then we invite him to show us.
Right, but you haven't received them
sent
at all.
that.
I understand why you refer to the document production statement. I understand that, but what you're saying is you have not, so far as you're aware, you haven't received these documents before. Is that what you're saying?
You would need to check
Okay.
all the email
Check.
correspondence
Okay.
because there's just so much to
Yes,
go through.
I think we all can agree on that. Let's hear from Mr. Galtcev then.
Thank you, Your Honor. Just first of all, it's difficult to believe for me that lawyers from the claimant side, they don't know how to use portal. So this submission was made by 9 of February as a standard production of the documentation.
Production.
Yes,
Right.
9 of February, I can show where is it on a portal. And Your Honor, I want to ask you to pay your attention that we spend a lot of time on different things around it, except the direct evidence and direct things related with the deal. I would like you to pay attention on the question of videos and social media that were uploaded after the disclosure deadlines. So I would like to mark that we are going to go to them and we are going to not let them be in a bundle because they are late. But
I think we've already dealt with the video evidence that was attached to the revised particulars of claim. Is that correct, Ms. Amani?
Yes, Your Honour.
Right. Okay. So I think we've dealt with the video evidence. Let's just be clear about this. Your submission, Mr. Galtcev, is that with your standard production, again, I'm looking at my case management order of the 12th of December. It says standard production of documents in accordance with RDC 28.15 shall be made by the 2nd of February. I understand, I presume it was extended or you filed late, Mr. Galtcev. For the avoidance of doubt, standard production of document shall include all documents which a party has shared with an expert instructed by it in order to enable that expert to produce an expert opinion report. So your submission is that you did produce those documents with standard disclosure, and I suppose it's possible that the claimant has not accessed it, and presumably they will check shortly. Is it shared with me again? Is that the?
Your Honor, I will try to check it right now.
Thank you. Right. So all the documents, yes, all the documents in the supplementary bundle are from this February disclosure by the defendants. Is that correct?
That's correct. So the claimant side tells about audited, because all other documents they found it. I suppose so. They didn't find state audited financials. They were uploaded in the portal as a general. It's a general disclosure, and I'm not aware, do they have access or not? So I'm not the owner of the portal. So if they didn't have anything that time, so they could send like notification or the ask or objection. I don't know how to say at that time. But if they didn't, I suppose so they had everything. So because I'm not an expert in the portal, I uploaded this. So, and what I can do.
I understand. Listen, it's good that this has been flushed out. These are important documents. They've been ordered to be produced. And I think the claimant was not aware that they were produced. So I think it's extremely helpful that we have now flushed this issue out. Yes, Mr. Galtcev.
Can I ask the court, so once the claimant tells something, just they can share the screen and prove that what they see, because from my side, looks like they tell that they don't see, they don't have something, etc. But we can be sure that it's truth.
I trust the claimant solicitors to be telling us truthfully what they find or don't find on the portal. I don't think we need to concern ourselves with that. Yes, Ms. Amani.
Your Excellency, we've just been going through the documents on the portal for February, and I'm advised that those documents were not in those non-standard case-related documents that are on the portal. The documents in the supplemental bundle are not there.
Okay. We're going to, afterwards, I suggest you liaise with the registry and we can try and see why those documents are not visible. Let's focus on the supplementary bundle. It has these documents that you've been asking for, the valuation documents, and you asked for them most recently at the beginning of this hearing. So presumably those documents can now all go in the trial bundle, and you can separately, please do investigate if Mr. Galtcev says they were uploaded. I don't know if there's an issue with the portal, really. And I don't know if an issue can be made of this, but we can leave that to you to investigate. And if you wish to make any points arising from it, you may make those a trial. But for present purposes, focusing on what documents are going in the trial bundle, presumably the defendant's supplementary bundle is something that the claimant wishes to be included in the trial bundle. Is that correct?
Your Excellency, we've not had a chance to look at those documents. As far as we are aware at this point in time, they were not disclosed. They were not produced during production. There's a substantial amount of material to go through there. We would then have to change our submissions, our skeleton arguments. We would have to analyse those. You know, as lawyers, we are not accountants or financial advisors or be able to, or competent to go through such complex financial documents. It's not within our remit.
Okay, but you've asked for these documents and you've got them, right? We think you've got them. I haven't looked at the bundle in detail myself. So how do you propose that we proceed? Let's assume you've got the documents that you asked me for at the beginning of this hearing, the valuation documents. You now have them. So you've got the documents that you wanted. How do you propose to proceed then?
Just one point, Your Honour, my assistant has just advised me that they were not sent by email either, and they're not on the portal, so that they have not been produced.
I understand,
and they are now in the supplemental bundle.
Right.
I would submit that for fairness and equity, if the defendant is allowed to submit late documents, then we should also be allowed to submit late documents.
You've asked for these documents. Ms. Amani, you have asked for these documents. You asked for these documents you asked for the documents. You said, I want these valuation documents. I don't know when they were disclosed. I'm not connecting this to your request for the revised particulars of claim exhibits to be introduced. That's a separate issue, right? You asked for these documents. They are the documents that were given to the expert. I fully understand why they are relevant and why the claimant has been asking for them. And I fully accept that there's an issue as to when they were disclosed. It's not clear, but it's fortunate that this has been flushed out because you've been asking for these documents. So what do you want to do with them? Do you want these documents? You've asked for them. You've got them. If you wish to make issues about how they were disclosed, I don't have enough information to be able to make any directions relating to that at the moment. But the point is you've got the documents. The purpose of today's hearing is to sort out the trial bundle. So how would you like to proceed?
Your Excellency, 2 points. When I asked for the production of those documents, I was not aware that the court would not allow the evidence that we had submitted back in October to be...
That is not true, Ms. Amani, because you said now that those documents are not going to be allowed on the record, we have very scant documents. This is my recollection, and please excuse me if I'm mistaken, but I seem to remember very clearly, please correct me if I'm mistaken, but I recall you saying, as a result of that, we now have very scant documents and we would request the court to ask for the documents that were provided to the defendant's expert. So it is not my recollection. We can go back, I can check the transcript, we can check the recording. Unless I'm mistaken, and please tell me if I am, that is not the case. You knew that the revised particulars of claim documents and were not on the case record, that we decided this at the very, I discussed this with both parties at the very beginning. And that was, my recollection is that's what prompted this request for these documents. So that you said they were relevant because you had scant, the word you used was scant. And then I recall inviting you to focus on the financial data that the claimant has exhibited to her witness statement and looking at the financial data that we already have before we explored further these specific documents that were being asked for.
Okay, yes, Your Excellency. So the amount of data there, I don't, right now, I've not been able to go through all that data that's been disclosed. I don't know what it includes. I don't know how long it's going to take for us to understand it and what the implications of that are. And I feel that it would jeopardize the trial timetable because we would need to get somebody to look into that.
Now, the documents that you just asked for an hour ago, you don't want them now. You don't want all the valuation data that was provided to the expert of the defendants. And I'm sorry, what point were you going to make when you said that when you asked for these documents, you weren't aware that the revised particulars of claim exhibits were not going to be admitted to the record? I apologise, I interrupted you, but what was the point that you were going to make?
The point I was going to make was prior to this hearing, I understood it that those documents that we disclosed in December would be allowed in, and that I was going to make the point that the valuation documents weren't provided. During the course of this proceedings, things have moved on, and we've discussed various things in relation to those particulars that were struck out, and we have now discovered this supplemental bundle and the disclosure documents. I would need to take instructions from my client regarding this because there's a substantial amount of material in there. When I was making my initial point, it was regarding the main valuation report that said 2024. I assumed that would be one document. I didn't appreciate that there'd be this volume of documents. So now it's very difficult for me to make a decision without the client's instructions on how we're going to handle this material and whether we should be, whether we would wish for it to be kept in or not at this late stage. And if it is kept in, then, and it is useful to the court and it is relevant, then the whole trial timetable will be jeopardized because we do need to instruct somebody who's competent to understand all of that, to read it.
Ms. Samani, we are not adjourning this trial again. Please let me be very clear about that. The trial of this claim, of your client's claim, is going ahead on the 18th and 19th of August with whichever advocate with full Part 2 rights of audience that the claimant wishes to instruct is going to appear on her behalf. We are not adjourning that trial. Okay, that's the first point. Now, the second point is I understand your concern that these documents may have been only just disclosed in the supplementary bundle because they're not the claimant. From your investigation so far, you've not been able to find them on the portal or in an email, though I understand you may wish to check further. Is that correct?
Just so that we're not making an incorrect submission to the court, we would like to check, but from our assessment so far, from the matters we've checked so far, we can't find this, and it's material documents.
Well, we know it's material. You just asked for it. You said we want these documents because we have scant data and we need these valuation documents. So yes, I don't think anyone disputes that they are relevant documents. Yes, Mr. Galtcev.
Yes, Your Honor, these documents are right there. So
are you showing us the portal? Yes.
Yes, DFC portal. 9 of February.
Yes.
two attached files. So standard production of documents, Appendix A, B, C. So we need to wait a few seconds. So basically, this is 119 pages of audited statements that were in the production and related to this question. They had all the chances to explore it before because it was filed 9th of February.
Okay.
The same data, the same exact data is in a supplementary bundle so far. So once the claimant says that they didn't have any chance to explore it, so that's not true.
Okay, Mr. Galtcev, is there anything else in the supplementary bundle? There's this data, your standard production of documents. Is there anything else?
I need to check, but everything was disclosed through the portal, nothing outside of the portal. So following your order, Your Honor, so your navigation was just for claimant to download everything that from the portal and upload to the bundle. That's if I remember correctly. So what they did, they upload everything from their side and they upload nothing from my side. And once I send it, literally by one email, second email, they didn't do this. That's why I was asking you to reserve at least one day to clean it all, because this is why I was I had to spend the time and money to make a supplementary bundle, because they were rejecting my ask a few times by emails, and I was presenting this documentation with links, with PDFs. So if they claim that they hadn't seen it before, and it was on a portal in my emails with all links provided, etc. So
it seems there's some misunderstanding. I understand your position.
It's difficult to believe.
Galtcev, but I understand their position is there is some misunderstanding and they have not seen these documents. Yes, Ms. Amani.
Yes, Your Honour. I can't share my screen because I had to log on to a different machine. But I don't know if you can see this, but there is no 9th of February in our. There is no 9th of February. Okay, sorry. I don't know how else to share this with you. But there is no 9th of February sort of button for us to press on the computer. Perhaps I can go back to my original PC where it's opened and see if I can rejoin and screen share from there.
I don't disbelieve you. I don't disbelieve you. I don't know what the issue is. I understand what you're saying. Yes, Mr. Galtcev.
Your Honor, we previously, through the process, where like some team of mine, like lawyers, helped me to file all this, because it's already 2 years and probably I need to apply for my legal license already because of this case. So we had similar problems. And we were asking like claimant a lot of times to share with us their documentation, and they shared the last moment every time. But in this case, if they didn't have a standard production documentation following the order, and they didn't ask, and they didn't have it in a portal, they needed to send objections that they didn't receive anything.
I think they did. From memory, I think that there were orders sought on the basis that the defendants didn't disclose anything. I may be mistaken, but I don't believe it's the first time that the claimant has said that these documents have not been produced. I may be mistaken. My recollection may well be mistaken, but unfortunately, this issue was not flushed out. Yes.
Sorry, Your Honor, that is the first time I heard objection about they didn't have something. So
I may be wrong. I may be wrong. Ms. Amani, there have been some requests for further production. Is that correct? Asking for the experts' documents? It's possible I'm mistaken.
I can't recall, Your Honour. Perhaps Alice could, because Alice was dealing with all of this part. and I wasn't involved in the creation of the bundles or the correspondence between the parties or anything, so I can't say from myself.
Right.
But we definitely do not have that tab on our system that says 9th of February. It just does not exist. I can take a screenshot and email it to the court right now.
The point is, let me just try and just see whether, because I should have access to everything.
Ninth of April, right? 9th of Feb.
While I'm doing this, Mr. Galtcev, could you please assist us? I just want to know what else is in your supplementary bundle other than these documents. Would you mind reviewing it for a moment while I'm checking my own portal, just so we could make sure we've dealt with everything that's in the supplementary bundle?
Yes, Your Honor. I can share my screen and we can go through it like in a few minutes. Literally, it's short.
Okay, so I have this disclosure. It's on the 9th of February. It's on my my case portal.
Your Excellency, I'm just about to send a screenshot of what we can see.
I've told you I don't disbelieve you. I don't disbelieve you, but I do have it. It has been filed. I don't know if there's an issue with what's visible for you, whether you need to click on what Mr. Galtcev said, shared with me, or if you need to take it up with the registry. But as far as I can tell, these documents have been filed.
May I just ask Mr. Galtcev to just direct us on where these would be, just so that we can clarify it straight away. I'm looking at the main case area, not the share bundles area, but just the main timeline where documents are submitted.
Case events.
Case events, yes.
Yeah, it's in case events on the 9th of February.
Yes, we don't have that, Your Honour.
Your Honor, I just checked the supplementary bundle. So what's inside? Everything inside the production. Are you able to see my screen? Because this is a new feature, I don't know.
I don't see your screen, but that's fine. I can follow what you're saying. So yes.
So it's first your order to force, I don't know how to say, force production of disclosure.
Yes. That's all. I think that's all. Is that not already in the trial bundle? No.
I suppose so, Your Honor, but
Okay.
I was afraid with all these iterations and volumes and new editions of new bundles, they will be able to miss something, and it was impossible to check 1,300 pages every time they want to add something. Second, it's a chronology of events from claimant. This also chronology was somewhere inside different documentation, very difficult to find.
It was in the claimant's disclosure, I think.
Yes, it was in the claimant disclosure.
Okay.
Yes. Then first time it wasn't in the bundle, second time it wasn't in the bundle. So, and the third time it finally was in the bundle between junk files.
Okay.
So, then my objection to the witness statement was to the claimant witness statement, I suppose so. It's not objection, it's answer. Reply for the witness.
We don't have that milestone, replying to witness statements. That's not a milestone I recognize.
I don't know how to say it. So,
okay.
Defendant's reply to claimant witness statement.
Okay.
Yeah. So it's inside. So it's also in a portal. Then we have audited reports. That's what we were spoken about now. All of them.
Yes.
And at the end, final 3 screenshots from Lehman, which were disclosed by the claimant, follow your order of disclosure with communication with Lehman relied on valuations and etc. So these 3 screenshots also inside the supplementary bundle, because I also was afraid they can just remove it and I just can't find them. That's all what I see so far.
Okay, all right, thank you. I suggest that we proceed as follows. Mr. Galtcev, those documents, I have requested the claimant to prepare a trial bundle index, which sets out the document, the name of the document, just a very brief description, the date of the document, and then one column, the date it was disclosed. For all of your documents disclosed on the 9th of February, for the moment, just put the 9th of February. I'll deal in a moment what we do about the fact that the claimant can't seem to access them. And I would like you to share that index with the claimant. The only document that I'm not sure about is your reply to the claimant's witness statement, because I don't recall any procedural milestone where there was a reply to a witness statement. But just put it in the index and you will share it with the claimant. Mr. Marnie, you will do the same for your index. You'll produce an index with the same columns that I have described. And I suggest you include everything that has been disclosed that we have discussed. So pleadings, documents attached to pleadings, and standard production of documents. And well, the claimant, I think the defendant's standard production of documents will already be dealt with in the supplementary bundle, and documents produced in response to requests to produce. I'm going to suggest that I'll give you, today is Tuesday. I want these indexes shared with each other by Thursday. Thursday at 10 a.m. UAE time. And then if there are any objections to any of the documents, and there really shouldn't be, or at least, again, I don't know about this defendant's reply to witness statement, but all the other documents should be extremely straightforward. The indexes and any objection should be filed with the court by 10 a.m. UAE time on Friday, so we can move forward and get some kind of bundle arranged. In relation to this issue, Ms. Amani, you do not seem to be able to see this document. Reem, may I ask you please from the registry to liaise with Ms. Amani? It may be that IT may need to assist, and I want to make sure that there are no other filings by the defendant that the claimant is unable to access. I think we've dealt with the supplementary bundle now, which again was filed. It's on my portal. But Reem, would you be able to liaise with Ms. Amani, please?
Certainly, Your Honor. Ms. Amani, yes. Please can you send an email to the registry saying that you don't have access to certain documents, and then we can work with the IT department to then provide you with access, please.
And Reem, just sorry to interrupt, just to be absolutely clear, I think it would be helpful if somebody could go over every single case event that has been filed. I just want to make sure there's nothing else missing. And then I want to understand what the reason is that the claimant cannot access these documents. Okay?
Certainly, Your Honor.
Thank you very much. And then please update me once that has happened. I'd very much like to see if that might be possible today. I think we really need to get to the bottom of this. Okay?
Indeed.
And then if you want to send me, Ms. Amani, this case that you rely on, you can send it immediately to the registry. just send the case. And sorry, what was the provision of the, was it rule 4 that you relied on a rule about, you referring to the court being able to disregard any procedural irregularity? What rule was that?
Rule 4.51.
Okay. You can literally just send an email to the registry attaching the case, and you can just say that case needs to be placed before me. All right?
Yes, Your Honour.
Once you've liaised with the registry today and we understand what's going on with access to the portal, and once you've had an opportunity, I'll be updated and I can decide how to proceed. But you also need to decide by the end of tomorrow if there is, depending on where investigations lead, what your position is on the documents, the experts' documents that you requested and that we've now been able to locate. All right, so I need an email to the registry, please, tomorrow, setting out the claimant's position. And then I need the trial bundle indexes exchanged between the claimant and the defendants Thursday morning, 10 a.m. UAE time, and then sent to me by 10 a.m. UAE time on Friday with a very short bullet point note if there is anything that's objected to. I will be issuing a written order, but I want to wait to see where things land today with this portal issue. So I trust that these timelines will be obeyed in the interim. And my directions of yesterday still stand, which is that the trial is going to be adjourned to the 18th and 19th of August to commence at 10 a.m. UAE time, and that the claimant does not have leave to file a reply skeleton argument. Just for your benefit, Miss Amani, what I said yesterday is that there'll be a full opportunity to respond in opening. We will not be rushed for time. We can have 1 hour openings. And if the parties wish, it may be possible. I may be willing to consider allowing an oral closing and even a written closing, or even just a written closing, so that everybody has got all the written submissions they want placed before the court. Okay? Is there anything else before we adjourn now? Miss Amani?
Yes, Your Honour, I just want to make sure we've got the correct notes on the index. You said the index with the correct columns, so that would be dates and descriptions, would it?
Each document needs to be described separately. They're not going to be all lumped together. So each specific document, whether it's, you know, one email or one presentation or one pitch deck, the date of the document, if it's available, and then a separate column when it was disclosed. And actually, when you say when it was disclosed, what it was disclosed with. So, for example, for Mr. Galtzev's production on the 9th of February, he would say these documents were disclosed as standard production of documents on the 9th of February. Okay, and if you produce something that's with the particulars of claim, and I think strictly speaking, everything's supposed to be produced with standard production, but be that as it may, just please be specific about when it was disclosed. Is that clear?
Yes, and just check pleadings, document attached to pleadings, standard production of documents, and we're not including the defendant's reply to the witness statement.
I haven't seen that document. I have to look at it. Mr. Galtcev wants it included. I don't know when it was filed, but when you produce that index, Mr. Galtcev, you can please indicate when you filed that document, where it can be, so I'll know what date to look at on the case portal. So I will look at that, but you can look at whether there's any other documents you object to. It shouldn't be for me to tell you what's been properly disclosed and is on the active case record. I've just given you examples. You will need to go to the case record, but needless to say, anything which has been struck off, like the revised particulars of claim, I do not consider as being part of the active case record. Okay? Is that clear?
Yes.
That clear, Mr. Galtcev?
Yes, Your Honour, that's clear.
Thank you very much. You have your hand up. Was there something further you wanted to say? No. Yes.
Yes, I would like to point attention on one specific document that were produced after the disclosure date. Can I?
Yes.
because I'm afraid it's so much questions and we're going to forget about it totally.
Yes.
Screen. Are you able to see my screen now?
Yes.
Okay, so it's Lechman 1081, 1080, 1081. 1081. Yeah, so basically this email that shows us that the meeting between Lechman and Anastasiia was made in 9 of May. And this document, as also this transaction documentation, weren't produced under disclosure and under order, after the order. I'm fine with this transaction because I was asking them many times, and just on the final bundle I have seen them finally. But I'm against this kind of proof that we have a meeting with between Anastasiia and Victor, because I already have seen and understand I understand the story, how it's going to be told this. But this documentation wasn't disclosed at all before the double deadline of disclosure. And again, so the claimant told few times that they exhausted all searches, and finally I have seen this documentation that is going to be, they're going to rely on this doc telling their stories. So that's why I asked to remove it, because it was after. Frankly speaking, so I know what kind of stories they're going to tell, and based on this, it proves nothing. But I just want to be clear that after disclosure and after the order, after the second iteration of disclosure, you probably want to remember I asked that they didn't disclose anything, and then I have found this file between the files. So also just want to pay your attention on this.
Right, so just so I'm clear, you want the transaction document to go in proving payment.
I'm not against transaction document, so proving payment.
But your position is still that it was not disclosed. The transaction document.
I mean, I was asking myself this documentation.
Oh, right. Okay.
That's
okay.
why
Right.
I can be against, right? So I was asking myself, and they weren't produced on under the statement of truth, but after they appeared in a bundle, this two transactions statement. So I'm not against because I was asking for them, but I'm against this not significant, but
the meeting. Yes, I've got it.
Meeting, yeah, because
yes.
it wasn't disclosed before, and she signed a statement of truth twice. That's what I remember. And also, like this video has also appeared after, and this video is like also proven nothing. But I just want the story that is going to be told at the trial is going to be clear based on the documentation that was on the production. I hope you understand what you mean.
I understand that you have an objection based on the non-disclosure of these documents and putting them into the trial bundle. Yes, Ms. Amani.
Yes, Your Honour, just to respond to that, it's the claimant's position that disclosure was made of these documents, albeit it was attached to particulars of amended particulars of claim that were struck out, and that's our position.
Okay. Do you both agree that you want this transaction document in? Do you want to keep it in, the transaction, the proof of payment?
Yes,
because
Your
if
Honour.
you both agree, I'm content to allow in an agreed document. I have no issue with that. But anything else that's not on the record, we'll stick to what we have discussed and what I have directed about documents to go into the trial bundle and the index and the clear date of when they were disclosed. All right, is that clear?
Yes.
Okay, thank you very much, both of you. I think this has been helpful and we've flushed out issues. I do hope that Ms. Amani, it's possible to get to the bottom of this portal issue. Yes, Mr. Galtcev.
Your Honor, we still have a question about social media screenshots, and a lot of them that it's in a bundle.
Those documents, are they attached to the revised particulars of claim? Have they been disclosed before? So they've gone. They're gone if they're revised particulars of claim. Is there anything else, Ms. Amani? Any other social media? Yeah. Anyway, this will all be resolved because all that we're going to have in the trial bundle now is everything that has been disclosed that's not been struck out, apart from that one document that you've both agreed should go in. So I think that deals with all of these documents. Okay?
Okay, thank you.
I suggest we leave it there. Thank you very much. Please, I hope you've made a good note of my directions because, as I say, the order will may not be out for a couple of days. I think we've still got some things to get to the bottom of. All right?
Yes, Your Honour, sorry, I just remembered I have shared the screenshot of the portal already live. Yes, I have. Yes, I just wanted to say that. That's all.
That's fine. Thank you very much indeed. Thank you.
Okay, thank you.
We are now we're now adjourned, and you will receive an order, but you are to proceed according to the timetable I have directed. Thank you.
Okay, thank you.